Welcome, students. In the previous classes, we have discussed about the media laws and salient features of Indian Constitution. Now, coming to discuss on the press commissions and laws relating to the defamation. Various laws related to the rights, media, and human rights. All we will discuss in this session. So first we will go with the laws relating to the defamation. This is unit number 4. In this unit, we have covered contempt of the court and indecent representation of women prohibition act and children's act, defamation, various sections related to the media. Earlier there is a IPC sections, now BNS sections. Bharat Nyaya Samhita. So earlier Indian Penal Code, just rename the sections. Media, the popular term used as a press, it denotes the print and electronic information carriers through the newspapers, magazines, radio, television, and currently we have a new media. That is a digital media, social media. And we call the press also as a fourth stage. Media is the watchdog of public affairs, informing the society and vice versa, and acts as the forum to advocate the views of the society at large to those at the help of public affairs in the democracy. We know in the democracy, we will run with the various laws by the and there is a constitution. We have based on the constitution only all the process, all the ruling run by the government, ruling government. As we know, we have a in this Indian context, what happens? The print media and its interference with the law have a long tradition, while radio and television, the new media, internet, etc. Various practitioners, lawyers, and educationalists relating to the mass communication need to understand the legal framework that is operational and emerging debates of restructuring legal frameworks. This happens every when they're required, it will be happens. We see very regularly the laws related guidelines as codes, laws related to the media issues by various bodies like the Press Council of India, otherwise self-regulations by the own media houses. So look at coming to the main act, that is a contempt of the court. This act enacted in the year 1971. We have a freedom of speech and expression is one of the fundamental rights given in Article 19 of 1 of A, and there is no separate act, there is no separate right for the media, for the press, because it is included in the article only 19 of 1 of A. That is says that expression, freedom of expression. That means every citizen has its own freedom. There is no separate rights for the press or journalists or media. Media's role is watchdog role. Already we have discussed many times. It is that every trial is conducted fairly, openly, and above the board. Any misconduct in the trial is sure to receive notice in the press and subsequent condemnation by public opinion. So this act, no political system will be regarded worth is name without an effective. In the parliament, like parliament, the judiciary system is different. There is a separate organization in government. So judiciary is not a part of the parliament, but the acts were made, acts prepared in the parliament only, but the judiciary is an independent body, so they takes the all their they have a right, they have some privileges for the judiciary. So we as a journalism students, we have as journalism students or journalists, we have to be maintain that guidelines, privileges given to the special privileges given to the parliament members, assembly members, and some judicial. So while we have to writing, while we are writing the our news articles, we have to keep it in these sections because those have some special privileges. So based on this point only, we have to write our news articles. When judiciary has to perform such responsible and it takes, it has some vested with the power, judiciary, and such power is to punish the contempt of court. There is a high courts are given this power statutorily. There is a no contempt of court powers to the local government session courts or municipal courts, but high court and upper means supreme court. There has a power, the courts as a power, even though this is applies to the any sessions courts or municipal courts, whatever it is. But while we are to covering the news related to the courts or verdicts, but we must be cautious and we have to be follow the guidelines by the this act, even though by the time to time changes in the guidelines by Press Council of India. Contempt of court means this first we will look in. The contempt of court was passed to define and limit the powers of a certain courts in punishing for contempt of courts and to regulate their procedure in relation thereof. The Contempt of Court Act of 1971 codifies certain concepts and the technology of English common law that has gone into the legal currency of India. So what will be in the year 1952, the civil and criminal contempts. Thus, this has been become more elaborate, and then the act is there is a previously there is one act 1952 related to the contempt of court, but it is now what happened revised in the year 1971 again. So this is first this is the act now we are using still. So what will cover under this act? Contempt of, what is the meaning of contempt of court? The contempt of court means civil contempt or criminal contempt. What is the civil contempt means willfully disobedience to any judgment, decrees, directions, order, or writ, or other process of court, or willful breach of an undertaking given to a court. The term a willful breach of an undertaking given to a court. The term willful means is important in the definition that there is a no contempt if the person who has violated the uh, orders by the court had no knowledge of it. Means some we see some places if any person who was a person with disabled, so there is a no, it is the person is not applies this contempt of court act. So here obedience. For example, if one judgment is out, we have as a reporters, we have no uh, no choice, no opinion to discriminate that judgment. We could not say the judge is not given a right decision, right order. So whatever the judge, whatever the verdict, so just we have to mention in our newspaper, but we could not evaluate the judgment as a reporter. Not even though in case the persons who are applies to that judgment, they have a right to go with the upper appeal to the next level court. So as a reporter, we could not say whether the judge is given a wrong decision or a wrong order or wrong verdict. So please, we have to keep it in these words. And coming to the criminal contempt. Criminal contempt means the publication. So this is applies to our, whether by words spoken or written or by signs or by visual representation or any other forms. Here, visual representation means in the electronic media, maybe it is a radio or a television or signs, visual representation, even though in newspaper also, in photographs, in a written form or a spoken form, whatever it is. So it is applies to the electronic media and print media. So we could not violate what we have earlier discussed. So we could not say the verdict given by some particular judge or a justice. So we could not say that is not good, that is not right. We are not the judge. Only we have to write what the verdict delivered. So just we have to write it. Not we could not assess it. Scandalize or tends to scandalize our lawyers or tends to lower the authority of any court, or this comes and this is so we could not give in any type of written or visual signs, all this. We could not interfere, we could not tends to interfere with the due course of any judicial proceedings. For example, there is the verdict will not come in one single appearance. It will take 3-4 times or many times. So we could not, in between it, the matter is in court at law, we could not interfere. We have to mention it, just the procedure is going on, the next hearing is this one, like this only. But we could not judge it is very long. As a reporter, we could not mention in our newspaper or television. So we could not interfere. Interfere or tends to interfere with abstracts or tends to abstract the administration of justice in any other manner also is a criminal contempt of court. So we have to keep it in all these points while writing our news. So coming to the focuses on the criminal contempt and the press, what will be happens? As far as the press is concerned, it is a more involved in the criminal contempt of a court rather than civil contempt. Sometimes the press reporters or editors who also goes to the court to give their explanation. There is a punishment, there is a penalties. So there is a hearing also. So we can also have a right to give our expressions, our hearing in the court in case of anything we will get it. Defense. This is also called the defense. We have a right to defend ourselves. There are certain defenses provided under the act. They are in case of that publication is innocent publication and distribution of matter is not contempt. So we have to be defend in the court in case of anyone file against us. Maybe any justice or judge who files against a reporter, the civil contempt of the court or criminal contempt of the court, there we can defend ourselves. We have to give our opinion. Maybe that is an innocent publication, or that may be a fair and accurate report of a judicial proceedings is not a contempt. And fair criticism of a judicial act is not contempt. So some defenses as a journalism students we have to be independent. Now coming to the another section, that is indecent representation of women, Prohibition Act 1986. The Indecent Representation of Women Prohibition Act, this act is enacted in the year 1986. Who will administer by who will look in this section, this act? The Department of Women and Child Development, Ministry of Human Resources Development. This ministry will look in these matters. As per this act provides for the regulation of representation of women in media. Mainly we see in case of any there is many contradictions, many oppositions about this section, this act, because the actor women who are interested to act in some vulgar scenes, so that will be happens. But in mainly we will see the advertisements, some films. But even though the act gives some regulations. Based on the regulation only, we have to mention in newspapers or in media. This act provides for the regulation of representation of women in media. It is an act to prohibit indecent representation of women through advertisements or in publications, writings, paintings, figures, or any other manner, and for the matters concerned therewith are incidental thereto. So these are the prohibited things in the advertisement as well as in the publication. Prohibition of advertisements containing indecent representation of women is not accepted, even though children also we will discuss in a couple of slides. Prohibition of publication or sending by post of books, pamphlets, etc. containing indecent representation of women is also not acceptable in the print media, electronic media, whatever it is. So there is a sections in the act that is That is mentioned. That is mentioned section 4, various sections. There is a 4A, 4C, 4 like in the sections. So there is a point here we have to recall it because section 4 of A of this Act 1 says that provides exception to any book, pamphlet or a paper or side film or writing or a representation of a figure, publication of this which is justified on the ground of science, literature, art, or some other objects of general concern. There is an exception. For example, if we see in a science, in a biological science, it is required for that book. It is required a person's various organs should be mentioned in that book. So it is exception for that serious, that kind of a matter only, not for the entire print media, electronic media, like what we are calling about the mass communication. Only exception for a few. The images of naked birth giving goddesses are certainly part of the Indian religious iconography. So here is it is objectable. So we don't give any related to the which is in a violation of law and order. So we could not give. Maybe that is not related to the children or a woman or a person. So we have certain guidelines by the Press Council of India. Based on the guidelines only, we have to write our text. Now coming to the Children's Act. In this act was passed by the Indian Parliament in December 1960 to provide for the care, protection, maintenance, welfare, training, education, trial, and rehabilitation of neglected and criminal children for the union territories. These what will be covered all these items. So children, this act may be regarded as a model piece of legislation for the whole country. The Children Act has also been rightly regarded as the most recent instrument for the juvenile corrections in India. See, while we have to write the name, we could not mention the name of a minor, we could not mention the name of a juvenile. So even though a prisoner name also we could not mention in sometimes based on the subject matter. So victim's name we could not mention in our media in related to the some children or some related to the women. So while we have to keep it all these instance, these acts and all this, we will be cautious while writing the news. The act provides for two agencies. One is a child welfare board to deal with the neglected children, and the other one is the children's courts for delinquent children. In fact, the composition and functions of both these agencies are the same as that of the juvenile court in other parts of the world. So based on that only this act is implemented. The basic principle involved in a legal procedure pertaining to juvenile delinquent in the India under the above act, the elsewhere in the advanced countries of the world, that it should not smack of criminal proceedings. The procedure should be in a conformity with the principles that the child should not have the stigma of criminality attached to his behavior or her behavior. The juvenile court procedure should have no semblance with the procedure of a criminal court, but the special atmosphere should be that of a child guidance clinic or a parent counseling service. All these procedures included in the act. There is some more about the act we need to know. See, in case of a we see in the newspaper any minor, maybe he is he is involved in any crime, we could not mention, even though that is he is a boy or a girl, whatever it is. So under the minority age, we could not mention their name in the content, our news content. Dear students, if you have any doubts, you may raise your hand. Otherwise, you can type in the chat box. I will read it and I will give you the clarifications of the doubts. This is a more interactively session. You can participate and you can exchange your thoughts and your ideas, your opinions with me. We will share the various aspects, subject matters in chit chat. Now coming to the another act, another important thing is defamation. Defamation is common about a person that tends to hurt the person's reputation. We see in a regular basis, in a regular newspapers and various media organizations, we see many leaders or political leaders or even though representatives, public representatives, they use the word of defamation. They ask to file the defamation for some amount. This is a very regular practice, regularly happens in our society. So we see this defamation word in a regular basis. Defamation is a strict liability tort, which means the intentions of the defamer are not relevant. The communication must be made to other people, not just to the person it's about. The statement must be false to be classified as a defamation. If it is spoken, then defamation is termed as a slander. If it is written, the term is libel. So we will know what is the detailed about these various types. Now coming to the libel defamation, what will be? Libel is the type of a defamation with a permanent record, like a newspaper, a letter, a website posting, an email, a picture, or radio or TV broadcast. So it is you think that there is no permanent picture in a TV, but the slide appears on the other second. That is also content. A radio voice also is a part in the libel defamation. If you can prove that someone libel you, then a court will presume that you suffered damages and award you money for your damaged reputation. We see in many cases, a regular basis in the newspapers and media are written by the various public representatives, celebrities. They come to the media and they announce that they are filing a libel defamation case against the damaged of the damage for the worth of amount by defamer. In deciding on the damages, the court will consider your position and reputation in the community. For example, if you are a professional, damages by maybe higher, you will get. There is again the court procedures will continue as how the other cases. Once it is approved, means once it is stated that is what happens, it is in case it is found real, it is found true, you will get the punishment also. Here is some let's we take about other type of a defamation, that is slander. Slander is the type of defamation with no permanent record. Earlier it is a libel for is a permanent record, but here slander is a no permanent, means on spot, on chit-chat spoken statement. Normally it's a spoken statement with between the two persons or in a group or whatever it is. So there is no record. It can also be a hand gesture, sometimes something similar, means if we do some signs, also comes under slander. The law treats slander differently from libel defamation. With slander, you have to prove you suffered damage in the form of financial loss to get compensation. But with the libel, the law presumes you suffered damages. Here is some explanations also. For example, if in case of a defamation, you have to give explanations also, that will be considered. In case the explanation is suitable and it is adjustable, the court will release you. Means it will dispose. That will be clear that that case without any punishments, without any orders. So explanation like it is amount to defamation, to input anything to a deceased person, or if the imputation would harm the reputation of that person if living, and it's intended to be hurtfully to the feelings of his family or other near relatives. So this is one explanation. Another one is it may be amount to defamation to make an imputation or a company, reputation of a company or association or a collection of a person as such. One more explanation is that an imputation in the form of an alternative or expressed in ironically may amount to defamation. Explanation, another explanation is no imputation is said to harm a person's reputation unless that imputation directly or indirectly in the estimation of others lowers their moral. So these are some other conditions also. These are the some explanation about the defamation. We can file our case in the court, in the court of law, and we will get as in case of if anyone who feel that their reputation is damaged, they have a right to file the case in the court of law. There is a sections in the new in a book. We have mentioned some sections related to the media, but now it has been changed with the new Bharat Nyaya Samhita (BNS). But the core is core points are the same. But in the textbook means the present textbook which we have supplied to you, we have distributed to you, which is prepared in the 2017. So now the new sections come in force in a very recent, means like 2024-23 only. But in the textbook we have is still IPC sections. Don't be confused with the IPC sections and BNS. Both are same. So some sections, the numbers are changed, and some slightly changes are made in the new BNS, Bharat Nyaya Samhita, even though the core points which are already taken from the previous section, previous term only, means Indian Penal Code only. Some sections, because now we have mentioned in the book about the IPC sections. So once I suggest the students go with the media related sections, new sections which are mentioned in the BNS. Okay, Bharat Nyaya Samhita. So far here I am concluding this session, concluding this unit, because here in this unit we have discussed about the representation of indecent representation of women, Children Act, and also Defamation Act, and also about the contempt of court. There is some more privileges for the parliamentary proceedings also we will discuss in coming sessions. Now I think that I hope if you have any doubts you may ask now, otherwise I will go with a new chapter. The new chapter is laws relating to the rights, because every human, every citizen of India has some rights already, which are mentioned in our constitution. Our constitution gives every citizen of India has some rights: freedom of speech, expression, freedom of education, freedom to get education. These all are related to some rights. In unit number 5, that is laws relating to rights of a citizen of India. Right? There is no confusion. There is some in this unit we will cover various topics, various subtopics like Official Secrets Acts, Right to Information Act, Intellectual Property Rights, Copyright Act, and Right to Privacy. These are rights related to the media, not only the media exactly, but various cases will come from the media only, because this is applies to all other sections also, not exclusively for the media, means newspaper or electronic or print media, but mainly in our society mainly focuses the text, means various material available, printed material available in the newspapers and various newspapers and electronic media. So that is why this topic, this unit included in the syllabus, laws related to the rights. The right one is, the first one is right to information. Related to the media only we are discussing here. Right to Information Act, Intellectual Property Act, Copyright Act, and right to privacy. While we are as a journalism student, journalist, we are covering some individual interview with a person of individual interviews. There is we have to keep it the right to privacy. Right to privacy. Every person has a privacy right. So we must be keep it in our mind while interviewing, while mentioning in our newspapers, while mentioning in our electronic or print media, radio, television, whatever it is, in the new media also. That is in digital media or new media, whatever it is. So right to privacy is also one kind of privilege to the every citizen given by the Indian Constitution. Now let's we discuss about the focus on the Official Secrets Act. What this act mentions, why there is a controversy between the Official Secrets Act versus Right to Information Act. Right to Information Act is enacted in the year 2005, very 21 years ago, and there is a Official Secrets Act which is adopted by the British laws only, which is already mentioned. It is enacted in the year 1923 only. 1923 under the British rule only it is enacted. The still act, the act still it is running. This Official Secrets Act. So Official Secrets Act is about anti-espionage. Well, coming to the Official Secrets Act. Official secret is defined as a piece of confidential information that is important for national security and it should be protected. Official Secrets Act come into force in the year 1923. The act extended to the whole country and applies also to servants of the government and to citizens of India who are living outside India also. Outside India also it is applies, but a citizen of India. The act states that one cannot approach, inspect, or even pass over a prohibited place or a government site. See, many where we see all these prohibition related notices at military areas. In the city also, for example, some cantonments, there is a prohibition, there is a mention, a notice board which is planted nearby that premises about the prohibition area. Another one is helping the enemy state in any manner can be in the form of communicating as a sketch, plan, model of an official secret or of official passwords or official codes to the enemy is a punishable crime under the Act. Here are some documentation clarifications because many there is a controversy between the Right to Information Act and the Official Secret Act. There is a reporter says that that will comes under the Right to Information Act, but the official says that that is comes under the Official Secrets Act. So there is a clash between these two acts. So we will discuss. First, we have to classification. First, we classified the documentation or information which is comes under this act, this Official Secrets Act. The classified information is categorized into two different types in India, which includes top secret, highest level of classified information. Next one is a secret. Secret information also would cause serious damage to national security. Coming to the another part is a confidential. Confidential information would cause damage or be harmful to national security. Another one is restricted. Restricted information would cause adverse effects if publicly available. It is meant only for official use and which is not to be published or communicated to any person except for official purposes. Many times it will be a clash between the RTA, Right to Information Act, and was Official Secrets Act. Official says that in case of they don't want to furnish the details, they just say that this is comes under the Official Secrets Act. But in many cases, it will be not come. This is proven by many cases, many court cases, many verdicts proven. So that is why we, whatever in case it is suitable to us, means as a journalism students, so we may be asked to give the information. There is some non-classified, unclassified documents also is there. The non-classified information is information which does not require any special protection. There is no need for media to take a clearance for publishing non-classified information. Here is a permission. Why permission is required here? Even though some categories we have talked about in a previous slide, that is maybe a secret one, maybe that is a top secret one. In case that is mentioned by the official persons, we have to write in our newspapers. There is no problem. What will be the punishments? If any person for any purpose harmful to the safety and security of interest of the country will be punishable under the Official Secrets Act. Punishment under the Official Secrets Act ranges from 3 to 14 years of imprisonment. A person who is prosecuted under this act can be charged with the crime even if the action was unintentional and not intended to endanger the security of India. But there is a punishment by the punishment is under this act. Maybe it is even though unintentionally, sometimes we see some persons express means they gives their opinion that we have unintentionally entered in that restricted area of a military, if they don't know. But even they are also punishable. Coming to the Right to Information Act, this is a very much important to us. As a journalism students, we have to know about the details about all the sections, various punishments, various the guidelines by the under this act. This act is enacted in the year 2005 on June 15, and it came into force on October 12 of the year 2005. This act was enacted to provide for setting out the practical regime of right to information for citizens in the country to secure access to information under the control of public authorities in order to promote accountability and transparency in the working of each public authority. All the government institution and the institution funded by the government or the institution funded by the some NGOs, public sector units, colleges, universities of a government sector, all these comes under this act. All these organizations comes under this act. In case of any NGO which is funded by the government, also comes under the Right to Information Act. So we can see information from those NGO also. So while we have to approach them, we have to check whether they are funded by the government or government agencies. Objective of the right to information. The major objective of the Right to Information Act is to empower the citizens of India, promote transparency and accountability in the working of government-run institutions. Maybe that is a public sector unit or pure government institution, or maybe that is a government college. Every maybe sometimes military controlled offices also comes under the Right to Information Act. But the information is related to the national security that may not be furnished. Other informations like salary, general auditing related to the any developments, any general issues, general matter, we can take in from the even military agencies also. The RTI Act is an important step towards making the citizens informed about the activities of the government. For the purpose of discharging duties, central and state information commissions were set up in the country. There is a two levels at the central level, Central Information Commission, and at the state level, there is also State Information Commissions of each individual state government states. Coming to the CIC, Central Information Commission. CIC is set up under the Right to Information Act. It is the authorized body established in 2005 to act upon the complaints received by them. The CIC consists of one Chief Information Commissioner and not more than 10 Information Commissioners. The CIC and ICIS Information Commissioners are appointed by the President of India. Now coming to the state level. At the state level, there is a State Information Commissioner, State Chief Information Commissioner, and not more than 10 State Information Commissioners. They are appointed by the Governor of concerned state. The term for CA Information Commissioners of 5 years. There is a process for RT application. Every citizen can has a right. They have to apply. You may write in a format, or you may write in an ordinary white paper. Also, you can write whatever information you want. You have to write, and you can see. There is an exemption for the fee payment also. There is a initial fee payment about ₹10. You may pay the cash to the public information officer and take a receipt. Otherwise, you can mention postal order on the application, means attach it. Otherwise, in a physical also we can give. Indian postal order of 10 rupees with your application. There is a penalty in case of the particular organization, public information officer who is not give you the who is not furnished the information what you are seeking. There is a punishment. There is a penalties. Sometimes we can go to the appellate authority. Every institution there is a need to mention the public information officer's name and also appellate authority and also first appellate authority and this second appellate authority. First appellate authority who is a person of that office only maybe sometimes some many times and second appellate authority means the information commissioners, state information commission or central information commission. In case we could not get proper information, we could not get the in-time information, there is a limitation for 30 days. And in sometimes it will be extended up to more 15 days, 45 days is the limitation for the furnishing the information to the seeker. In case the information is you could not get in time, you can approach, you can go to the appellate authority or second appellate authority, like that is a state information commissioners or central information commissioners. There is some amount of fine after appeals hearing by the information commissioners. They give the penalty with some amount is imposed for each day. Some amount also mentioned in the act. Some 250 rupees per day. Like how many days delayed, that much amount will be to be given to the seeker. So many cases it will be not applies, it is not implemented. But even though in information commissioners also they use one more chance to the PIOs, information officers at public information officers at government office, they order the PIOs, they gives again one more deadline to furnish the information. Dear students, so far we have discussed in this session various two main things about the Official Secrets Act, another matter related to the Information Right to Information Act. Here it is the time to conclude this session. We will discuss in a next session about the Intellectual Property Acts and Copyright Acts, other acts related to the gender in general and also focused to the media. Thank you very much for participating in this online classes. Once again, thank you.